You're standing in the finance office. The paperwork is in front of you, and somewhere in that stack is a warranty booklet that everyone in the building has told you is your protection. But here's the question nobody in that room wants you to ask. What happens to that booklet if the company that printed it stops existing? Not goes out of style, not gets bought, stops existing, files bankruptcy, liquidates, closes the doors, and turns your brand new coach into something the industry has an actual name for. They call it an orphan. Today, I'm going to walk you through exactly what happens to your warranty when a manufacturer files, what survives that filing, what dies with it, and the specific questions you ask at the dealership to find out which one you're buying before you sign anything. I spent 17 years as an Army contracting officer, DIWEA Level 3, Army Acquisition Corps. My entire job was reading contracts and answering one question over and over. If this goes wrong, who is legally on the hook? And can they actually pay? That is the exact same question you should be asking about an RV warranty. Not, is it covered? Who is obligated? And are they solvent? Those are two completely different questions, and the RV industry does a beautiful job of blurring them together. This is not a hypothetical episode. Look at where the industry is sitting. Manufacturers shipped meaningfully fewer RVs in the first 4 months of this year than they did over the same stretch last year, a double-digit percentage drop. The RV Industry Association turned around and cut its full-year forecast well below last year's numbers. And shipments are the optimistic half of the picture. Shipments measure what manufacturers pushed out to dealers. Consumer registrations measure what real human beings actually bought and put plates on. Those fell harder, roughly a fifth, year over year in the spring months. When Reuters sends a reporter to Elkhart, Indiana, to write about the RV downturn, the story has gone mainstream. Now, I'm not predicting anyone's bankruptcy, and I'm not naming names. What I'm telling you is that we have seen this exact setup before, in 2008 and 2009. This same combination, a demand collapse landing on top of an inventory glut, took out National RV, Fleetwood, Monaco Coach, and Country Coach. Those were not fly-by-night operations. Some of them built the best coaches in the business at the time. The people who bought RVs in 2007 got a warranty booklet too. There are two very different things people mean when they say went bankrupt, and the difference decides your outcome. Chapter 11 is reorganization. The company keeps operating under court supervision while it restructures its debt. In a Chapter 11, the debtor frequently asks the court for authority to keep honoring warranties because a manufacturer that publicly abandons its owners has destroyed the brand equity it's trying to save. So in a reorganization, there's a real chance your coverage keeps functioning. Chapter 7 is liquidation. The doors close, a trustee sells the assets, and the proceeds get distributed to creditors in a legally fixed order. Secured creditors first, then priority claims, then general unsecured creditors. Your warranty claim is a general unsecured claim. You are at the back of the line, behind the banks, behind the suppliers, behind the landlords. Now, here's the nuance that almost nobody explains correctly, and it's the part I want you to actually remember. Your warranty obligation does not legally evaporate the moment they file. Technically, it's still there. The problem is that it stops being enforceable on two levels at once. Level 1, legally. When a company files, the court issues what's called an automatic stay. That stay stops other legal actions cold. You cannot sue for breach of warranty. The courthouse door closes. Level 2, practically. Your dealer's service department can't get authorization from a manufacturer that no longer answers the phone. And even if they did work, they have no realistic expectation of ever getting reimbursed. So they decline the job, or they hand you an estimate and ask for your credit card. That's the orphan. The dealer sold you the RV. The dealer did not build it. And when the builder is gone, the dealer has no one to bill. I want to be fair to dealers here, because this next part explains a lot of behavior people find infuriating. There's a well-known independent RV shop owner in California who has talked publicly about what the last crash did to him. Before 2008, roughly 3/4 of his shop's workload was manufacturer warranty work. When manufacturers started closing their doors, he went unpaid on work he had already completed in the neighborhood of $150,000. He had to close the business and file bankruptcy himself. He now refuses to take manufacturer warranty work at all. That is why the dealer will take care of you is not a plan. Okay, just take a deep breath, because the doom and gloom version of this video, it ends right here, and the accurate version doesn't. You do not have one warranty. You have a stack of them, and only the top layer dies with the manufacturer. Stop thinking of your RV as a product. It's an assembly. The coach manufacturer bought a chassis, bought axles, bought appliances, bought an air conditioner, bought a water heater, bought a converter, bought slide mechanisms, bought tires, and then bolted a box around all of it. Every single one of those components came with its own warranty from its own company, and that company has no idea your coach builder went under and doesn't care. Your chassis warranty is with the chassis maker. Your appliance warranties are with the appliance makers. Your suspension, your axles, your brakes, your air conditioning, those are separate. Separate companies, separate obligations, all still standing. A warranty attorney put this well years ago. An RV owner actually has significantly more protection available than a car owner does when a nameplate dies. A car is one company's product. An RV is a dozen companies' products in a trailer-shaped wrapper. So what do you actually lose? You lose the coach manufacturer's structural and workmanship coverage. Roof, sidewall, delamination, frame, water intrusion, seams, slide box, construction, fit and finish, how the whole thing was put together. And here's the bitter irony. That's where the expensive failures live. Nobody gets financially ruined by a failed water heater. People get ruined by a roof that leaks for 2 years into a wall cavity. So the stack is real protection, but it's protection on the components, not on the box. One more thing before we get to the questions, because this one fools people. When a manufacturer goes under, the brand name usually doesn't die. It gets sold. Here's a real example from the last cycle. When a company called Viking Recreational Vehicles went under, Forest River acquired the intellectual property, the brand names, the product designs, the manufacturing facility. The entity carrying the debt filed bankruptcy separately. So you have a situation where the badge on the trailer is alive and well, being built by a healthy company, and the entity that owed the warranty on your unit is a shell in bankruptcy court. The rule to remember: in a bankruptcy sale, assets get bought and liabilities get discharged. A buyer purchases the name because the name has value. They do not purchase your warranty claim because that has negative value. If you see a brand disappear and reappear, that is not reassurance. That is a signal to find out which legal entity is on your paperwork. Now we get to the part that actually protects you, and this is the contracting officer talking here. The manufacturer's factory warranty is the thing that dies. The service contract, what the finance office will call an extended warranty, is the thing that can survive if it's structured correctly. And whether it's structured correctly is something you can verify in about 90 seconds, standing right there at the desk. Service contracts are not regulated federally. They're regulated state by state, and the requirements are a patchwork. But nearly every state is trying to solve the same problem, making sure that if the company selling you the contract goes broke, somebody still pays your claims. States generally accept one of three forms of financial backing: a funded reserve account, where a large chunk of what you paid is locked away for claims; a corporate guarantee, available only to providers with enormous net equity; or a reimbursement insurance policy, where a licensed insurance company stands behind the provider's obligations. And here is the gift the regulators gave you. In most states, the contract has to tell you which one you're getting, in plain language, printed on the document. If there's an insurer behind it, the contract must contain a statement along the lines of, the obligations of the provider under this service contract are insured under a service contract reimbursement insurance policy. If there isn't, it must say something like, the obligations of the provider under this service contract are backed by the full faith and credit of the provider. Read that second one again. Full faith and credit of the provider. That is regulator language for, if this company folds, there is nobody standing behind this piece of paper. That sentence is somewhere in the contract you're about to sign. Find it, read it out loud, watch the room. And one more piece of good news: where a reimbursement policy exists, the protection typically doesn't unwind if that policy is later canceled. The insurer generally stays responsible for the contracts that were already issued before the termination date. Your protection attaches at the moment of sale. There's even a specialized insurance product built for precisely this scenario, a failure to perform policy, sometimes called a surety clip, that insures nothing except the obligator's inability to perform because of bankruptcy, insolvency, or ceasing to do business. That product exists because this risk is real enough that an entire insurance market grew up around it. Okay, 6 questions. Ask them in this order, and ask them before you're in the finance office, because by then you're emotionally committed and legal obligor on this service contract. Not who sold it to me, who is legally required to pay the claim, the dealership, the manufacturer, or a third-party provider. Show me their name on the document. And are they licensed as a service contract provider in my state? Number 2, is this contract insured or backed by the provider's full faith and credit? Point to the paragraph. If it's insured, who is the insurer? And are they admitted in my state? Write the name down. Number 3, give me the component warranty list. Which systems are covered by their own manufacturers? For how long? And do I have to register any of them separately? That list is your survival kit if the coach builder disappears, and most buyers never ask it. Some component warranties require registration within a short window after purchase. Miss it, and you've thrown away the coverage that would have outlived the manufacturer. Number 4, if the coach manufacturer stops authorizing claims, will this dealership still perform structural work? And on what terms? Ask for the answer in writing. If they won't put it in writing, you have your answer. Number 5, will titling this in a business or LLC name affect warranty standing? Get that in writing too. Buyers have been told titling to an LLC makes no difference, then discovered a commercial use exclusion that voided the coverage. A verbal assurance from a salesperson is worth exactly nothing against a printed exclusion. And number 6, can I put the deposit on a credit card? If a manufacturer collapses between your order and your delivery, chargeback rights are one of the few remedies that actually works quickly. A wire transfer or a check has no such mechanism. Let's close the loop on the legal protections. And I'm going to be straight with you rather than sell you false comfort. The Magnuson-Moss Warranty Act is the big federal one, and it does real work. It governs how warranties must be written, labeled, and disclosed. It restricts a manufacturer's ability to gut your implied warranties. And it lets a prevailing consumer recover attorney's fees, which is why warranty attorneys will take these cases at all. What it does not do is create a fund. It gives you a cause of action, and a cause of action requires a defendant who exists and has money. State lemon laws vary enormously. Most of them apply to motorhomes, cover the chassis and drivetrain, and not the living quarters. A number of states exclude towables entirely, and they run into the same wall. No solvent defendant, no remedy. Implied warranties under the Uniform Commercial Code run against the seller, which is one reason dealer-level obligations matter more than most buyers realize, and one reason I keep pushing you to get dealer commitments in writing. Federal recall obligations through the National Highway Traffic Safety Administration are real, while the company is real. In a liquidation, there is no practical mechanism to compel a dissolved entity to remedy anything. So here's a sentence I want you to leave with. The laws protect you from a manufacturer that behaves badly. They do not protect you from a manufacturer that ceases to exist. Only the contract does that. None of this means don't buy an RV. I love RVs, and I'm not here to talk you out of living the RV life. What it does mean is I want you to buy the paperwork with the same attention you gave the floor plan. You spent 4 hours deciding between 2 sofa configurations, You spend 20 minutes finding out who is legally obligated to fix your roof if the name on the front of it stops existing. Ask the 6 questions. Get the answers in writing. And if the room gets uncomfortable when you ask who the obligor is, that discomfort is information. Thank you for watching.